Welcome back. I have Joanna Barron and Christine Van Geyn, authors of this newly released book, Pandemic Panic: How Canadian Government Responses to COVID-19 Changed Civil Liberties Forever. Very interesting read. Joanna, just before we went to commercial break, we were unpacking the Emergencies Act. Why don't you pick up where you left off?
Sure. So as I mentioned, when the act was invoked, Canadians were wondering, is there more evidence? Because this looks to us like a highly disruptive but largely peaceful protest in downtown Ottawa. And of course, at that time, the Ambassador Bridge, the blockade at Coots had already been cleared, which certainly presented huge problems. Were cleared using ordinary police powers. So I would say there were two significant things that we learned coming out of the Public Order Emergency Commission. The first was, as I mentioned, no law enforcement on the ground. The Ontario Provincial Police, the Ottawa Police, the RCMP, all of them had concluded that a threat to the security of Canada had not existed, as well as the director of CSIS, Bernard Vigneault. And the second thing that we learned was that the Prime Minister had prepared a very novel legal defense. He was extraordinarily well prepared during his cross-examination. He clearly had been fully briefed, but the argument that he made, because the Emergencies Act requires a threat to the security of Canada within the meaning of the CSIS Act, the argument he made was that it was a threat to the security of Canada within his understanding as governor in council, without pointing to any actual evidence of this. And we know that no alternative threat assessment to the police forces, was prepared. And when pushed on what the legal basis that the PM understood himself to be acting on, the commission was faced with vigorous claims of solicitor-client privilege. So we never learned, and Commissioner Rouleau asked this very directly, if the point of this commission is for me to ascertain whether you had a rational basis for acting, and you're refusing every pass at what was the information, what was the report, what was the legal opinion, you're just claiming solicitor-client privilege, how am I supposed to do my job?
Right. Now, Christine, of course, many eyes were on the Emergencies Act and the Commission, and that's a very big deal. But there are many smaller practical cases that some people would like to see litigated through the system. And I continually hear of cases being dismissed. Is this the case, that cases are being dismissed? And why would that happen? Is it for fear of setting judicial precedent? What's your take on this?
I don't think it's a fear of precedent, but it's a practical approach that a lot of courts took, was that they resolved cases on procedural grounds. And there were many cases like that. Now, we work with exceptional lawyers at the Canadian Constitution Foundation, and we successfully overcame claims of mootness in several cases. So the government tried to claim mootness in our judicial review of the use of the Emergencies Act. The court proceeded to hear the case on the merits anyway. The government in British Columbia claimed mootness in our legal challenge to that province's vaccine passport policy, because the policy was no longer in effect, but it didn't have a workable system of medical exemptions. That was our argument. And the court proceeded to hear that case on the merits anyway. So we were able to overcome these mootness concerns, but there were many, many cases that were resolved on procedural grounds, not just mootness, but at the lower level in British Columbia in our claim, the court kind of didn't get to the merits of the dispute because of a judicial principle called prematurity. So they said that there was an alternative resolution that should have been used in that case. Now, I don't know if I would say it's for fear of creating precedent rather than just judicial resources, and it's just the path of least resistance rather than engaging with very complex constitutional questions and issues in a novel fact scenario. But certainly we saw many cases. Roman Baber's case, for example, was resolved on procedural grounds. Many cases discussed throughout the book. And one of the things I'd point out is that a lot of the time the cases didn't even get to section 1 of the charter, which is where we balance rights violations and ask if those rights violations are justified. What we found was in a lot of cases, courts found that rights weren't even engaged. Wrongly, I think. I think a lot of these cases, rights were clearly engaged, but the courts just never even found there was a rights violation.
Yeah, and I'm not a lawyer, but as a laywoman, that's where I have concern that we will never really give this process a fair shake, and we will never see where things end up. We're going to pick this up in just a few moments.